Right, privilege, law, and LeBron James tweet. A heart must quiver and lungs shudder to think so despicable of practical public assumption that for 1 second the police officer was absolved of liability to the criminal deprivation of the civil rights of the child that he murdered. Oh, but an innocent one, yet detrimental, a mistake that succeeds the ever present reality of negligence or other forms of police misconduct on the part of ignorant public observance, potentially a similar fault of the officer. And it is important to note here, Ma'Khia Bryant is a victim and not a suspect. DictionaryLaw.com considers a prime suspect to be one that has been duly given Miranda warnings, plus to recognize and comprehend those rights. Hill and Hill 2021. Furthermore, a suspect is someone who is under suspicion, often formally announced as being under investigation by law enforcement officials. Inc. 2021. For all intent and purposes, how is it not an easy witness to review a moment of intensity and confusion that one would assume the actions of the officer to be justified because there was a weapon possessed by the victim and that the victim was in the act of apparent assault onto another person? Another person was at risk to injury by the hands and weapon of the victim, of course, but nonetheless, the problem is constitutional, both on the federal and state levels at least, about that instance of emotive instinct that brought the officer to discharge his weapon into the back of the victim. In any case, this is a brief opinion on the matter of a fatal Columbus City, Ohio police-involved shooting event that has caused controversy over like scenarios, but this issue is different. What is better of this opinion? Practically, to reach a full comprehension of the matter at hand, one should ponder the legal respect of these terms and their appropriate relevant legal placement. Felon, suspect, offense, escape, apprehend, seizure. Whatever the case, the argument can be made for both kinds of force or for excessive force alone. In this instance of officer-involved shooting. Quote, the Supreme Court has held that use of deadly force to prevent the escape of all felony suspects, whatever the circumstances, is constitutionally unreasonable. It is not better that all felony suspects die than that they escape. Downey, 2018. Quote, even though Leonid admitted that he behaved in a disorderly manner by refusing to immediately obey the police officers and by approaching one of them, this does not give the officers license to use disproportionate force to subdue him. Downey, 2018. Quote, the unnecessary use of force would be the application of force where there is no justification for its use, while an excessive use of force would be the application of more force than required where use of force is necessary. Downey, 2018. Legally, Section 2921.44 of the Ohio Revised Code entitled 29 Crimes Procedure and Chapter 2921 of Offenses Against Justice and Public Administration recognizes some forms of dereliction of duty as this. Section A2, quote, fail to prevent or halt the commission of an offense or to apprehend an offender when it is in the law enforcement officer's power to do so alone or with available assistance, Commission 2015. Section E, quote, no public servant shall recklessly fail to perform a duty expressly imposed by law with respect to the public servant's office or recklessly do any act expressly forbidden by law with respect to the public servant's office. Commission 2015. Quote, Section F. Whoever violates this section is guilty of dereliction of duty, a misdemeanor of the second degree. Commission 2015. On a glossed observance, the actions of the officer may seem legitimate. because he attempted to prevent apparent imminent injury affliction upon the other person by the victim. However, the officer never established any reasonableness. See Section 3 of the bibliography. In this decision to defend the other person against the victim, he never ascertained considerably the orientation and context of the situation and individuals involved, nor established any appropriate relationship on the scene. Even though he attempted to establish a relationship initially, when he involved himself, in the way the events unfolded, there could have been no appropriate determination about the identity of the offender. The apparent assault could have been defensive, and the knife could have been a defensive device by any superficial observation, and so the officer did not have the power to do so alone. See above Section A2. But the assistive tool is inadequate because of its deadly force capacity and the actual effect it caused. Another caveat of significance is the new law enacted by the state of Ohio that respects a stand your ground doctrine. Therefore, the victim had no duty to retreat from the threat of other persons if there was a perceived offensive threat on her part. Brookban 2021. Thus, the force power imposed onto the victim was excessive upon deployment and abusive. Simply, had he not intervened by the weight of the former clause, he would have been non-liable to Section 2921.44 because he was under no obligation to act upon the victim. In fact, it was against his best of interest to engage the victim with deadly force. The case of this community engagement avails itself to scrutiny of department policy and practice, as well the federal clause for police misconduct with regard to the sanction of deadly force particularly. To address department policy, the argument on any level can be that this officer acted lawfully with regard to Columbus Use of Force Police Division Directive, because Section 2A, subsection 3B, considers threat of harm or injury to others to be legitimate cause to use force, Columbus Police Department 2020. However, it should have been made clear already that the officer could not have assessed of any appropriate measure who the aggressor was, perpetrator of a crime, nor who the victim was, or if all parties were victims. Therefore, the real duty of care obliged of the officer was intervention of non-lethal force, or intervention without any physical force, but rather to observe and ascertain better for the care of the total community. Otherwise, the officer is guilty of selective enforcement. See Section 4 of the bibliography, a defense that is not accepted in Ohio law. Nonetheless, a federal civil rights violation. See Section 5 of bibliography of the law. Because he imposed prejudicious force of ignorant will and endangered the entire community seriously, the use of force imposed onto the victim by the powerful will of the officer, it may violate Department Policy Section 2A, subsection 4, Columbus Policy Department 2020. The statement regards punitive force, which is a possible reason for the course of action embarked onto by the officer when he discharged his firearm into the victim. It is probable, given the course of action, that the officer shot the victim because she would not comply with his commands. Simply, apparently, the officer judged and convicted the victim under the color of law and then seized her state right to stand her ground and her life. Section 2A, subsection 8A, lends itself to a survival of encounter to be requisite of necessity to techniques employed against resistance and aggression, which begs the reveal the officer was not in any danger. Subsequently, the policy statements of the Columbus Police Department continue to Section 2B. In subsection 1, there is consideration about legitimate deadly force. It is when the involved personnel have reason to believe the response is objectively reasonable to protect themselves or others from the imminent threat of death or serious physical harm. Columbus Police Department 2020. It should be made clear by now that the reason of the actions of the officer is in doubt. about the legitimacy of his. He was not in any position to select one for protection over the other. An abuse of power for sure. In subsection 4, there is a requisition of tact that involves verbal warning that is specific to deadly force, and the officer failed this requirement. Columbus Police Department 2020. With no special consideration given to her mental state, see section 6 of the bibliography, i.e., the obviousness of her oblivion to his presence and her engagement in such an intense potential moment of fight or flight, herself, she had no time to gain orientation to the presence of the officer nor to any immediate commands. The emotional impact of the decision to shoot first and ask questions later caused harm, surely, for all parties involved, but the father most incredibly, as he is whom witnessed his young child be murdered of shots to the back by the person there to help keep everyone safe, and to be so helpless but to look on and cry out in distressed horror. The actions of the officer violated this department policy drastically. The section 2B subsection 6, which speaks to an order of police protocol and practice that compels operative protection to the total community. Columbus Police Department 2020. He caused more harm than good. Police officers should not shoot upon mere sight of a gun or any weapon where inappropriate, because such is unconstitutional in effect of the First and Second Amendments, if not any other. The fact that dignity and life were taken through frequent and evidential police misconduct, it presents challenges to the integrity of public security rights and practices across the nation. Consequentially, about the actions of the officer in question, regardless of his intentions of the moment, the good opinion is that the officer is guilty of misconduct through negligence of his duty to protect the community they serve, its citizens, and their property. OSBA committees in sections 2015 in the state criminal and federal civil capacities. He should be tried for criminal transgression, sued for damages, and issued a permanent relief of professional police charge in the name of liberty and justice also, but for the sake of the betterment of police efficiency and safer communities. This opinion is influenced through the comparative reason of political expectation and ethical consideration, a determinative deduction of duty, principle, and valuation of life.